Mr. Scarry.
My Lord. If I may, to open, let me take to tab 8. My Lord, I'm using I'm different to what my friend in fact used because the bundle seems to be different. So I'm using the bundles that
We'll try to help
yes, please.
us all locate the bits that you want, Mr. Scarry.
Yes, please. My Lord.
Is this the authorities bundle?
The authority bundle, the index of
Tab
primary
8
authority.
is Fairfax, is that right?
Yeah?
Tab 8 is Fairfax.
Tab 8. Yes, please, my Lord.
There's 96 in there.
And, my Lord, I take his lordship straight to paragraph 76 to make my my point.
All right.
Oh, sorry. I wonder if I could just ask what that page number was that was being mentioned.
916, I think, possibly.
Yes.
Yes.
Paragraph 76 we are?
Thank you.
Yes, my
Very
Lord.
much.
And if I be permitted, it says, Justice of Appeal McCull said at 76, notwithstanding the apparent acceptance by Hunjay of the commanding and binding force of the statement in Grappelli, I am of the view that the statement has been read as standing for a more absolute rule than it can justify, at least in cases where the issue is identification of the plaintiff. One of the beauties of rejecting that view of Grappelli is that it accords with common sense. And I start with there. It accords with common sense. I say that simply to say, before I move on, my Lord, simply to say, one cannot publish or be allowed to publish a defamatory statement, a virulent statement against someone, and then say tomorrow, you all can look out for it tomorrow, I'm going to publish the names of this person. And then hold that because the names were not published or the name was not published in the first publication, then there is no action. The thought of defamation is not complete. Justice of Appeal went on to say, my Lord, it is a natural human response when confronted with serious allegations against an unnamed person to inquire as to the identity of that person. That may be done in the ways alluded to above, by inquiries of those who might suppose to have the relevant information, or in the 21st century, by access to electronic media, or by a variety of other ways. Hayward and Baltimore's ought not to be seen as representing exceptions to a rule as laid down in Grappelli. Rather, they should be seen as recognition that the rule was too broadly stated in the first place, as indeed Lord Denning acknowledged in Hayward when he readily accepted that the statement did not apply where the only question was one of identification. My Lord, there are differences, there are clear differences between the decision in Grappelli and the decision in Hayward. In Grappelli, it was clear, my Lord, that the court was making reference to an innocent publication. So the court was saying you can't complete, you ought to complete based on the first publication, or if published otherwise after, then you raise the question of an innuendo. My Lord, it cannot be that on the first publication the words are defamatory, and on the subsequent publication, there is a name called, and then one says, well, on our first publication, we didn't call any name, so you have to forget about the second publication. Lord, at paragraph 45 of the same judgment, please, my Lord.
Oh, 931, I think. Yes?
Yes, please. For completeness sake, let me start at paragraph 44. Just a few lines down when the Justice of Appeal said, for the law of defamation, publication takes place when the newspaper is read and comprehended, or the radio broadcast is heard and comprehended. In other words, publication depends on the content being received, that it is made clear, although in the context of occasions of the commission of the tort of defamation. In Dow Jones and Company versus Guntick, and in a judgment that ought not to be allowed to lie fallow, Palmer J. discussed what he plainly saw as the peculiarities of idiosyncrasies of the meaning of publication for the purposes of defamation. What we can draw from the cited passages in Guntick is that a defamatory imputation is not published in the sense used in the law of defamation until its defamatory meaning is received by the recipient. Thus, where the plaintiff is not named in the matter complained of, no defamatory imputation is published until a recipient of the publication makes the necessary identifying connection. Therefore, my Lord, it is when the names are published on the subsequent publication that the complete tort, that the defamation, the tort of defamation is completed. My Lord, to go back a bit, take you back a bit in relation to the Hayward and Thompson matter, and to distinguish it from Grappelli. There are a number of distinguishing features. In the first one, my Lord, the publication was innocent. Additionally, my Lord, Grappelli was not a case involving identification, but innuendo. Additionally, again, the defamatory facts were not known prior to the subsequent publication, which is different in the instant case.
Yes?
My Lord, let me take you again to tab 9 of the said primary authorities, the index.
What page?
Page 5.
5 of which volume?
The Grappelli, my Lord.
Grappelli.
Grappelli.
Right.
976.
Right. Well, that's 976. Thank you. Internal page 5. Let's get that.
And
That's 0980, perhaps. Yep.
at paragraph 5, my Lord, where Denning says, I prefer to go by the principle. Says, I prefer to go by the principle that in defamation a cause of action arises and a writ can be issued as soon as the words are published to a person knowing all the material facts. My Lord, when he says, knowing all the material facts, the material fact will include the names of the persons. It will include the names of the persons, my Lord. And my Lord, I want to make one other point, that Lord Denning at the time had in fact had sight of Hayward at first instance. And he reveals this at page 6. He says, so on both these points, it seems to me that we ought to give leave to appeal. I can understand the judge's difficulty. He was not referred to all the cases to which we referred. He was referred to a ruling of O'Connor J. at first instance, Hayward and Thompson unreported, November 9, 1979. That seems to me to be understandable on other grounds, but of no assistance here. So he was signaling, even before that matter came to the Court of Appeal, that he understood the grounds, he understood the reasoning upon which Justice O'Connor made his finding at first instance. At the same page, my Lord, under the Lord Justice Dunn, and I read, the principal question of law is whether, when extrinsic facts are relied on in support of an innuendo which arose after the publication, the original words, not defamatory in their ordinary and natural meaning, can have the defamatory meaning alleged in the innuendo. Again, what the court was doing, and it is the thread running through the entire judgment, is making reference to the fact that in Grappelli, the initial statement was one on the face, the original statement was one on the face of it, innocent. But like this case, like the instant case, my Lord, Hayward bears some similarity. My Lord, in the instant case, there was no innuendo, but what in fact you had was a vicious libelous attack on the respondents. And my submission, my Lord, is that the cause of action cannot be complete with the sole impugned publication. Not when the publishers, when the applicants, the appellants in this matter, my Lord, went on to galvanize the public and to say to them, knowing fully well, my Lord, that there was going to be an inquest in this matter, that you go to the inquest, look to the inquest, follow those particular proceedings. When that is done, my Lord, and the names are revealed, action is complete, please, my Lord. You have the statements made, you have the names revealed at that later date. And Pemberton J sums it up quite lucidly, my lord, when she says there must be sufficient nexus between the two sets of publication. In other words, it is necessary, therefore, to draw a conclusion that the defamatory words in the articles and editorial in which the officers were not named were of and concern the very persons named in the subsequent articles. Lord, the clear principles emanating from the authorities such as Hayward and Bradley is that a publisher, my lord, ought not to escape liability for publishing defamatory statements and revealing the names in another publication. And I dare say, my lord, if that were to be allowed, then the limb of the libelous limb of defamation will be made a mockery of. My lord, my friend says that it disturbs the thought of defamation, the way the thought of defamation is calibrated. Lord, I'm submitting it does not. What it in fact it does is to give effect to the mischief that the law of defamation itself seeks to remedy. And that is that one ought not to make libelous statements of persons or defamatory statements and then subsequently publishes the names of those persons. The thought is, my lord, is that if you make the statements now, you publish it, the names at another date, then the nexus is drawn. Once that nexus is drawn, then the statements, the subsequent statements can be relied upon. My lord, my submission is that the Court of Appeal was correct when it distinguished Hayward from Grappelli as what was Justice C. Prasad at first instance. Second place, bear with me 1 second.
Yes, of course, Mr. Scarron.
My lord, if I take the courts to the core bundle, and to the newspaper article, my lord,
Which one?
clear call for justice.
Which newspaper article?
The Daily Express opinion, clear call for justice. It's at the core bundle, my lord.
Is it the editorial you want us to look at?
Yes, please, my lord.
We've got it.
Yes, please.
Can anyone give me a electronic page number?
It's different. It's not electronic.
It doesn't produce the goods.
No, I don't think it would.
I'd just go to the core bundle and flick through, I suppose.
See, my lord, I've been working with what I've been given.
I've got it, it's all right.
Yes, it's, I guess, two.
Okay, let's proceed, Mr. Skerritt.
Yes, please. The last paragraph, please, my lord.
Certainly.
With the exclusive publication of the special branch report that those questions are well on their way to being answered. We now call on all citizens to pay close attention to the proceedings of the ordered inquest when it comes up at the magistrate's court, the better to ascertain whether justice is served. My lord, when the matter comes up at the magistrate's court, and there are two publications, and I will go to the first one. Forensic expert testifies.
Yes.
Yes, please. It says at the second to last paragraph, initial report stated that around 5:30 p.m., Northern Division officers were in inquiries along Churchill-Roosevelt Highway, Agua Santa Drive, when they intercepted a Nissan car with 4 men. But outside of that, apart from that, what one has is Wallerfield shootings clearly highlighted on that particular article. And then a reference is made to Northern Division, which is a branch, a division within the Trinidad and Tobago Police Service. So this is one division in a small country, please, my lord. So while this says Wallerfield shootings, the other article, self-preservation important, this one now refers to Wallerfield inquest. So there is no doubt that the articles, the later articles, refers and keeps the action alive. What it also goes on to say, my lord, in self-preservation, and second column, last paragraph on the second column, make reference to one of the deceased father. Goddard's father, Henry, was not shocked by the ruling. He felt there is no justice to be had in Trinidad and Tobago. So the entire thing, the inquest, was a cover-up based on the evidence which came out of court. So it was not just a reporting of the proceedings of the inquest. There were additional opinions added. There's a picture on that particular page that says, shot dead, teenagers, John, Steve, Charles. And then you have further the comments of an attorney, worst case of injustice. So it doesn't simply, my lord said, that the officers were exonerated. It continues to, in fact, say to the population, let me remind you, just in case, what this was all about. By the comments of the attorney, worsen case of injustice, and by putting a picture of the youngest person to be shot, and says, the father is saying the entire thing was a cover-up. So, my Lord, clearly, that was kept alive. It is one thing, my Lord, to report, but having reported as you did in the first two articles, when you go as far as calling the officers murderers, to come in the subsequent articles, having already said to the population, follow, let's see if we're going to have justice, follow the inquest proceedings, galvanize the population, knowing that there were several articles published prior to. You galvanize the population, and then you published on the subsequent articles comments that clearly indicates that the proceedings, that persons found the proceedings at the coroner's inquest to be a farce, so to speak. Clearly, my Lord, they have kept it alive. My Lord, I turn to the second issue.
Thank you.
My Lord, and I refer His Lordship to tab 5, and that is the Bradley case.
We don't have tabs, actually, but we can find the Bradley
Someone-
case without any difficulty. It's at 869.
Page 17 of at para 17, my Lord, this is
Does it have paragraph numbers? No. Page 17, perhaps?
page 17 of the judgment, please, my
Page
Lord.
17 internal. Yeah, okay, 0865, yes?
And to read the judgment of Justice Harding, when he says, this does not mean, and let me start at page 16 for completeness sake, because he's saying, I cannot agree with the judgment of Lord Denning in relation to intention. That intention must be part of all of this. That is, it is not the law. But he goes on, at 17 he said, this does not mean, however, the evidence that the same author and publisher have published a subsequent article linking the plaintiffs by name to the allegations previously made of two unarmed brothers of the same age as the plaintiffs, who were also brothers of the stated age, is inadmissible and must be excluded from consideration in the action based on the first article. To do so would be highly unrealistic in the sense that it will exclude from the jury's consideration material which every person of normal intelligence will consider relevant to the question, who was the first article published about? it is one thing to say that intention is neither necessary nor sufficient to constitute a libel. It is quite another to say that a specific article undoubtedly published in the same newspaper by the same journalist was an employee of the same defendant must be excluded from consideration on the question of identification. And this, my Lord, I submit is what this case is all about. The publication of a subsequent article. I'm submitting, my Lord, that this is not a question of an exception to the rule. This is a question of when does the tort, or when is the tort completed? And therefore, the subsequent publication must be, my Lord, must be allowed to be taken into consideration, as in the instant case, my Lord. At para, my Lord, if we look at the judgment of CPSAD J, I just want to refer to the judgment of CPSAD. CPSAD J.
Yes. Which paragraph, Mr.
50,
Skerrit?
52, my Lord.
52, very well.
What he did, my Lord, he says, due to the significant lapse of time between the publication of the first article and the editorial and the subsequent publication of the second defendant, and the fact that the subsequent publication spoke largely about the coroner's inquest without any reference to either the first article or the editorial, this court is of the view that the readers of the first article and editorial could not, at this time of the publication of the subsequent articles, nor within a reasonable time thereafter, make sufficient nexus between the said articles and the claimant. In fact, at the time of publication of the subsequent articles, where the claimants were named, the reasonable average reader would more likely than not have forgotten the tenor and purport of the first article and editorial. My Lord, my submission is that CPSAD J was wrong. He fell into error. He fell into error, my Lord, when he says that the first articles and the subsequent articles, the viewers, my Lord, could not have, or the readers could not have made the link. They could not have made the nexus. My Lord, he provided...
How much respect has to be paid to the decision of the trial judge on something like that, Mr. Skerrit?
Well, Lord, if it's a matter of fact, then a lot of respect ought to be paid to it, if it's a matter of fact. But, my Lord, I submit this is not really a matter of fact, but a matter of law. And he ought to have provided views. He provided absolutely no views. As a matter of fact, my Lord, he speculated. What Justice of Appeal Pemberton did at paragraph 37 of her judgment.
Yes.
37. Lord, what she did, my Lord, is to clearly formulate how the court ought to have looked at it. When she said, even though the lapse of time was 7 months in the context of the entire unusual events, and she spells what unusual events meant, what she meant by unusual event. And she says, the unusual events are igniting and fueling public interest and the circumstances surrounding it, coupled with the writer's or publisher's stated intent of keeping the issue alive by the reports of the inquest and the language used in the report. She says this time period is not so substantial so as to allow the trial judge to find that lapse of time was significant to displace the conclusion that the offending words in the first article and the editorial could be of and concerning the officers whose names were published in subsequent publication. Further, I must take into consideration that ours is a small country with a population of 1.3 million. This is considerably less than a larger country like the UK, or for that matter, a larger city, for instance, London. A lapse of 7 months between the publication of the first article and the editorial cannot be considered significant to displace the conclusion arrived at that the first article and the editorial were published of and concerning the officers. My Lord, CPSAT J does not say to us how he came to the conclusion that there was no nexus, how he came to the conclusion that the time of 7 months was insufficient. And when one examines CPSAT J's decision, as I pointed out, my Lord, in my own submission to this court, he seems to have made his decision seems not to have made a decision based on any fact, reasoned or informed consideration, but used the fact of the intervening period in comparison with Bradley and Hayward, and then use the factual difference to find that the intervening period between the impugned articles and the subsequent articles was too long. And that was clearly wrong. That was wrong, my Lord. If CPSAT J was to hold, or as he did, that the period was too long, or that there could not have been a nexus, or that there could not have been any evidence to show that the first articles and the second articles were read and linked by any person, then he must say how he come to that finding. He hasn't done so, my Lord. And what he does could only be said to be speculation. We're speculatory in that, please, my Lord. Lord, I want to deal with two other areas. The appellant raised the question of whether or not the subsequent articles ought to have been pleaded. My Lord,
They were pleaded, the subsequent articles.
Yes, my Lord, and that has been, and this is my point, my Lord. They were fact there. They were not made part of the prayers, but they were pleaded. So on the pleadings, the appellant knew the case that they had to in fact meet. My Lord, if one doesn't go far enough, and I am submitting that in our instance we had gone far enough so that they knew what the pleading, what the case that they had to meet was, it couldn't, my Lord, destroy the entire case. And I think Justice Pambleton of Appeal said that. And she was quite correct. It could not have destroyed the entire case. It would have been a matter of damages. But I am saying in our case, in this instant case, that it was sufficient. And it was unnecessary for Justice CPC to say that it was not pleaded, when in fact it was. It formed part of the pleadings.
I think the main pleading point, Mr. Skerritt, is what has been called ground 3 of the appeal, namely that you never pleaded any case that people in December would have been able to identify your clients from the articles. You've said to us this afternoon that the case turns on the nexus with the subsequent publications, and one gets the impression that you're not really relying, or perhaps you feel that at this stage you can't really rely upon any suggestion that people in December realized who the unnamed officers were, because that wasn't pleaded, and so Mr. Speaker says, clearly had to be, as CPC J found. That, I think, is the main pleading point. And is there much issue about that?
My Lord, was it necessary? That's the question. The first question is we asked, was it necessary that one says on the pleadings that John or Jack read the article? Especially in the case where this is one of a national newspaper publication, a national publication. So it would not be necessary to say that John read the article or John didn't read the article, as the case may be, my Lord.
Yes? Well,
My Lord, additionally, if I go further, the statement, the witness statement, please, my Lord.
yes, which page of volume 1?
That will be page 26 of the transcripts. One second. Transcripts ought to be in volume. Page 27.
Whose witness statement are we looking for, Mr. Skerritt?
Inspector Simon, my Lord.
Try to help you.
Before I go to the statement of Simon, please, my Lord.
Yes.
I'm going to the transcripts of the question asked by Mr. Hussein at first instance.
Okay.
What's the question that's asked that you're looking for?
Suspect is a question by Mr. Hussein where he asked the witness about his witness statement and what was contained in his witness statement.
If you could give a word, then I can search for it, a particular word. There's talk about his witness statement at 0387 in the electronic bundle, I think.
I think Lady Black has got it in one, hasn't she? This is Mr. Hussein's cross-examination of the
Yes, it is.
inspector.
Where he says, no, Inspector Simon, you have said in paragraph 5 of your witness statement.
Could you give us the page?
0387.
411 for that.
Oh, okay.
411 for that specific reference. Electronic. It begins now, Inspector Simon, you've said in paragraph 5 of your witness statement.
What page?
It's 411. 27 of 213.
Yes, please. 411. Question. Now, Inspector Simon, you have said in paragraph 5 of your witness statement, and I don't want to take you to it, I'll just read it very quickly to you. Because of the publication of the articles in the Trinidad, the Daily and Sunday Express newspaper, I have been referred to by my colleagues as a rogue officer, many of whom openly refuse to work alongside me on patrols, while members of the public has heard insults at me, saying that I'm a member of a killing squad in the police service, killing innocent people. I have worked many years in the police service trying to maintain my good character. I am now avoided by my friends and members of my community, some of whom used to give me information to help me perform my duties. Yes? Answer, yes, sir. At page 412.
And yes, sir, means yes, that's what it says.
Yes.
Yes, that's what my witness statement says. This is a bit that you quoted,
Yes, my lord.
you and Mr. Khan, in paragraph 56 of your case. So we read that,
Yes, my lord.
and we, at least I, thought to myself, well, counsel is simply reading out the witness statement, and the inspector is saying, yes, that's what I did say.
And it is
So
in
where
this,
does that take us?
so it is in the witness statement, my lord, and if the appellant's counsel made reference to it in his witness statement, then, and there was no objection to it in terms of the witness statement, then clearly, my lord, counsel for the respondents or counsel for the claimant downstairs was entitled to refer to it. Seeing a puzzled look on his lordship's face.
No.
Is your point here that, therefore, there was evidence that people had identified them?
Yes, please,
It
Madam.
was the evidence of the reaction that the police officers had experienced,
Yes, my lady.
and it came from the police officer himself.
Yes. And clearly,
That moves on from the pleading point, because, well, you carry on, but that's the point you were getting at.
Oh.
That the police officer gave the evidence that you say was necessary.
yes, please, my lady. And if so therefore there was evidence. I'm making this point because there was sufficient evidence, evidence that was not objected to, and evidence which, in my humble opinion, stands. But let me get back to the main.
Excuse me, it doesn't identify the date, does it? So we don't know which of the articles he's referring to. The witness. Maybe the witness statement tells us.
Beg your pardon, my lady?
Maybe the witness statement will identify when these observations were made by members of the public. But the crucial thing is whether they were in December, or at least before the June article.
No, I don't think the witness statements themselves identify the particular date, a date. But let me just.
We've got the bit in the witness statement. I've got it as 0080. Yes, the inspector's witness statement. And Lady Arden, I think, is right to have suspected that it's not specific about date. Indeed.
What did at paragraph?
I may be muddled about this, but wasn't the Sunday article a later article?
What at paragraph 5?
Just hold on while I remind myself. Yes, the Sunday article, there was only one Sunday article, was the 5th of July. And insofar as in paragraph 5, the inspector is talking about Daily Express articles and Sunday Express articles, he must be talking about all 4 articles, in particular including the June and July articles.
Yes, madam.
Because only the July article is a Sunday one. Am I right about that?
Yes, please, Ballard.
Yes. Very well. Anything more on the pleading point? Because I think at some stage, Mr. Skerritt, I would like to ask you about the second ground, which is the width of the exception, if that's rightly to be described. And what do you say about Mr. Speaker's point that you are reaching for the June and July articles because they name your clients, but you can't have it both ways. If you reach for those articles, you must also be reaching for an article which says that the inquest vindicated the police.
No, my lord, I do not agree with my friend's point that if I'm reaching for those 2 articles, then I must reach for the article that says there's vindication of the police. My lord, what has happened in those 2 articles? While I may accept that the articles, the last 2 articles, made reference to the outcome of the inquest, it didn't stay there, please, my lord. It didn't just stay at the outcome of the inquest. It gave the outcome of the inquest, saying, yes, they were vindicated, but the articles went on to give views, other views, please, my lord. So it is not just at vindication. It didn't stop there.
Indeed, as I understand it, the question of privilege under Section 13 of your Act, which we haven't actually got, but I think it's set out in the footnotes
Yes, ma'am.
to the appellant's argument, was not pleaded.
No, my lord.
There was a defence of fair comment about the December articles, which was rejected by the Court of Appeal. The Court of Appeal dealt with a fair comment
Yes, my lord.
defence, but I'm just trying to say it's separate because it deals with the December articles and was rejected by the Court of Appeal.
Yes.
But when we come to the argument that there's an exception because there was a report of the coroner's inquest in June, that defence was not pleaded and it may not be available because it has to be a fair and accurate report.
And I agree with that, yes, milady. It is not available it is not available to the appellant. It ought not to be available to the appellant in those circumstances at all, please, milady.
And it hasn't actually, with the argument that it's a fair and accurate report, hasn't actually been made to us.
No, please, milady.
And it wasn't, I mean, I think it's clear that that point was not taken for the Court of Appeal by Mr. Hussain, who then appeared.
Disclaimer, yes, please, my lord.
But is it also, I mean, is it also right that no point was taken about the vindication? And the only issue that seems to be argued in the Court of Appeal was really whether the length of time destroyed the nexus.
No point was taken in terms
It doesn't seem to be argued that, well, when you got to the second report, whatever the time was, it vindicated the police officers. Was that an argument put forward against you?
That was no argument downstairs, please, my lord.
No.
No.
Because, I mean, the point, as I understand it, when the Court of Appeal was saying the judge was plainly wrong, this is at page, well, it's paragraph 34 of the judgment, of the Court of Appeal judgment, which I've got at page 46 of the core bundle. They're saying, was the trial judge plainly wrong in the application of the Hayward test when he found that the various things were incapable of identifying the officers? So it was very much directed that rather narrow finding that they couldn't make the identification. It wasn't looking at the sort of broader point of whether actually it was vindicating them. Is that
Yes, please,
right?
my lord.
And then she goes on to say at paragraph 37, well, actually in a small country like Trinidad, to say that that connection couldn't be made, was putting it much too high. Is that how you understand it?
That's what I interpreted to please.
Yeah.
The trial judge never went into the issue which you have been arguing, that the firstly the editorial said watch for the inquest, told people to watch for the inquest, nor did he deal with the point that the June articles contained observations on the result and outcome of the inquest,
Yes,
which were critical of the police.
that's correct.
The questions unanswered were identified.
They will. Is there anything else, my lord, my lady?
I don't think that there is. Mr. Skerritt, we're very much obliged to you. Thank you. Now, Ms. Frances Brooks, are you going to follow?
She's not, my lord.
She is not. Very well. Mr. Speaker.
My lords, my ladies, briefly, standing back, can one have a cause of action requiring proof of three matters, two of which exist at one time: publication to third parties, the fact that the meaning is defamatory, and the third element does not exist, but one can leave that cause of action floating or inchoate for a period up to 6 or 7 months, or one might ask 6 or 7 years. I say not, and that is the crux here, is that you simply cannot, when you stand back and look at this, accept that you can leave a cause of action floating for such a long period of time. The crux of libel is damage to reputation as a result of publication to third parties, and the elements need to be together and coalesce together as at the date of publication. What is that date of publication? That can shift depending upon evidence. Ordinarily, for an article, it is the date that the article is published. But what you can't do is wait for publication to take place a lot later down the line. So as at the 2nd and 3rd of December here, I say there's no cause of action because the elements of the cause of action are not all in existence. What can you do here? In respect of the 2nd and 3rd of December article, you can identify individuals who you say read those and who identified them as the individuals referred to, and plead and prove an innuendo in that respect. So one could have said, I sue over the 2nd and 3rd articles. They're defamatory in these meanings. These are the individuals who read them and understood me to be referred to, and it was reasonable for them to do so, and I invite a finding of that kind. You could do that. You could sue in respect of the 3rd and 4th articles in June and July, and you can say publication takes place to third parties. They are defamatory of me because of what they say on their face, that this, for instance, is a different defamatory imputation, but a similar one, that the articles mean I got off unfairly. And therefore, by getting off unfairly in the inquest, I am, in fact, a rogue police officer. And you could create that cause of action. And then you could argue, if a defence is raised, a fair and accurate report, that it wasn't, in fact, a fair and accurate report because it intermingled material from individuals such as family members that rendered the report unfair and inaccurate. You could do that. You could, in principle, say that you sue on Articles 1 and 2, but you do from, as at the date, you do from say, August 2009. But then you have to build up a case that individuals read them at that point and understood them to refer to the individuals in the meanings. And that's difficult to do if they didn't remember, or the fade factor exists to ensure that they don't remember all of the facts in the earlier articles. So there are a number of things you can do to create a case. But what you can't do, I submit, is leave the cause of action floating from December 2008 until such time later that the cause of action might be complete at some unspecified time. That is contrary to principle, contrary to the Grappelli principle, but it's also profoundly uncertain. So if the argument was, and it wasn't raised, but if the argument was Articles 3 and 4 were defamatory of the 9 officers and they created causes of action in themselves, then it was open to them to sue on those articles. But as the statement of case makes clear, and as the court proceeded, they didn't do that. They simply relied upon Articles 3 and 4 for the fact that they named the officers and provided the extrinsic facts to complete the causes of action in respect of the first and second article. But they could have done it differently. Secondly, I don't accept that the first instance judge was speculating. There is a difference of opinion between the two judges, Mr. Justice Seepersand and Lady Justice Pemberton, on what are the findings of fact that are important when looking at what goes into the Hayward principle, so to speak. So, for instance, they disagree over the lapse of time. But this is a disagreement over findings of fact. And in particular, one point that is made by Her Ladyship at paragraph 37 is of evidence of the defendant fueling the public interest between December 2008 and June 2009.
You mean in the footnote?
In the footnote. Mm-hmm. So what is said in the footnote is igniting and fueling public interest and the circumstances surrounding it, coupled with the writer's stated intent of keeping the issue alive by the report of the inquest and the language used in the report. There wasn't any evidence before the court, at first instance or in the Court of Appeal, that the defendants were keeping this matter alive.
But they weren't they? I mean, at this point I hadn't really picked up enough. But I mean, the first articles are specifically saying 1 year on after this incident for the Wallingford Five, we still don't know the answers. So it's not a sort of coming out of, they are specifically, and no doubt for very good reason, saying this is a matter of major public interest, Wallingford Five, fatal blunder. So they are keeping it alive. I mean, for very good reasons. And so when you then get a 6 months, and they're saying, wait for the inquest, and then when 6 months go by and you get the inquest, was the judge entitled to say that they were not capable of identifying it, that couldn't be a nexus?
My point is slightly different. It's that there are no articles by the defendants between December 2008 and June 2009 keeping...
No, they say wait for the inquest. They sensibly wait for the inquest.
But they don't do anything else apart from that. So, Your Lordship, I take the point that they do say in 2008, of course they do, wait for the inquest. But they don't... One of the reasoning of Justice Pemberton in the Court of Appeal is that that 7 months, the gap of 7 months between the 2008 articles and the June and July articles of 2009 is not so substantial, and one of the reasons for that is because they were keeping the matter alive. And the point I make is, as it happens, they weren't in that period. If they were publishing each week, still no investigation, still no special warrant report, etc., then that may be a fair point to make, but that isn't in fact the factual situation. That's not what happens. There is a true gap between December 2008 and June 2009 when nothing is said by the defendants, and that was the evidence before the court.
But they branded the issue as, is it this right, the Wallingford issue. Each article has got that in the headline. So you've got 4 articles that, in a series. I don't know about Sir Peter Rawlinson's defence about argument based on saga or series. Is this part of the argo of defamation law as well?
No, my lady. It seemed to be something that he picked up on. It's not.
All right. But there is a series you can see, a thread. Right?
But there is a very large gap between, in this case, the December 2008 articles and the June and July 2009 articles. There was a very small gap, 1 week, in Hayward between the 2 articles about Sir Jack Hayward.
But you're just plucking one fact out of a basket of facts.
Yeah, just coming back to the point, one has to acknowledge, I submit, a fade factor in a period this long. One acknowledges a fade factor in the contempt cases when one asks the question whether substantial prejudice has been caused to a jury by the revelation in a newspaper article, for instance, that the defendant has criminal convictions or various other pieces of information. When one looks at contempt, for instance, one asks the substantial risk of serious prejudice, one looks into account the fade factor. How long ago was the revelation of information from the trial? And there is a big difference between revealing in that sort of situation that a defendant standing trial in a criminal case has a conviction and being told that a week before than it would be 7 months before. And there's a very big difference in a case of this kind where the information is 7 months earlier and there was nothing between the December and June and July articles. The defendants, my clients, didn't publish anything more but in that period to, as it said, keep the story alive.
Just wondering, all of this is premised on, all of your arguments premised on the fact that it's a finding of fact by the first instance judge. actually, one of his points is that there was no evidence led to show that anybody had made the connection. So that's, in a sense, an absence of a fact. Is it evaluation? Is it fact? And, well, it's just considering the role of the Court of Appeal in relation to that sort of situation.
Where the claimant is unnamed and you have to establish that that individual has been referred to and understood to be referred to, calling evidence that that individual has been understood to be referred to is admissible and is probably the best evidence one can find that that has in fact happened. Now, it's still an objective test, so even if you call a whole load of your friends and family to say, I recognise that person, the court still asks whether that's a reasonable finding. But it is extremely significant here that the claimant did not call anyone as to demonstrate that they were known, identified from the December articles, and they did not call anyone to say that they connected the December articles with the June and July articles. And the judge was entitled, properly so, to make that finding, that evidence was missing.
Mr. Speaker, would you agree with Mr. Skerritt that your point about the later articles being vindicatory, or perhaps one might have to qualify, essentially vindicatory, was not a point taken in either of the local courts?
From what one can tell, it doesn't appear to have been raised in the lower courts. But as a general proposition, you should not be allowed to extract the facts that suit you from an article and ignore the antidote that goes with them. So when one determines defamatory meaning in a libel action, one has to look at the whole publication. And the ordinary reasonable reader is taken to read the whole publication and not to simply put a blue pencil through the parts that they say are the most defamatory.
Remind us, where does this reference to bane and antidote come from?
It comes from the leading House of Lords decision is Charleston and News Group newspapers. But it may well have come out in Stockholm, which is in here. But the essential point, and it is made in the Stocker case, is that the ordinary reasonable reader...
Sorry, I can't hear you. Where are we looking now?
If we could go to Stocker and Stocker, which is at 1654. And it's at page 1665. The Supreme Court sets out the Jaynes principles, which are outlined by Sir Anthony Clark in the Court of Appeal, which are the rules relating to the determination of defamatory meaning. And at number 5 is the article must be read as a whole and any bane and antidote taken together.
If we pursue that for a moment, the earlier article is the report of the pathologist at the inquest. Is that vindicatory?
It is supportive of the police officer's point, because that's made in the 4th article. I accept that the 4th article is stronger, but the claimants don't distinguish between the 3rd and 4th articles. But the 4th article makes clear that the pathologist as evidence is supportive of their case. And the 4th article is very clear that the Magistrates' Court vindicates in its finding the officers.
What did you say was the case where Bain and Antidote first made their appearance?
The first 19th century classic is Chambers and Payne,
I thought you said Charleston.
but the modern appellate decision is Charleston, Charleston, and News Group newspapers. It's the House of Lords decision.
The reason I was asking about the forensic expert was, for example, it said that her evidence was that several of the wounds were defensive. Right-hand column midway.
Yes.
I appreciate what it said in the subsequent report, but there was a month between the two.
And there is no, it's down to the defendant, if that's what, the claimant, if they are going to argue that identification takes place in June on the basis of this.
It's never been argued that way.
No, it's never been argued. So
Anything else, Mr. Speaker?
just on the point that was being made about evidence being given, what happens is that objection was taken, and one can see in the re-examination at the end of Mr. Simon's evidence that objection is taken, the argument is had, the first instance judge rules upon the admissibility of it, and he gives his reasons for doing so in his judgment. And as I've explained in this morning, that isn't challenged on appeal. So, and it is straightforward. I say that if it's not pleaded, if it is objected to and the objection is ruled upon, that's the end of it. It's not for the Court of Appeal to resurrect it later, particularly when there's no ground of appeal, saying that the judge's discretion as to what evidence was admissible or not. So, unless your lordship, ladyships have anything further.
I think not, Mr. Speaker. Thank you very much. Mr. Skerritt, a new case was referred to just now. Stocker and Stocker. Can't pick and choose. Bain and Antidote to be taken together. Read the whole thing. Anything you'd like to say about that?
No, please, my lord.
No. Well, thank you very much indeed, Mr. Skerritt, Ms. Frances Brooks, Mr. Speaker, the solicitors, everybody involved. We're really grateful, and we'll take time to consider what judgment the board should give.